Good morning, sir. Can you see and hear me?
Yes, I can.
Thank you very much. This morning we're going to continue to hear from Mrs. Crichton, and we hope to finish by the first break of the day. Thank you. Mrs. Crichton, I said yesterday I'm going to deal today with some miscellaneous topics. The first relates to corporate governance and the overall structure of the business. You joined as head of legal in January 2010. Were your responsibilities set out somewhere in a document?
That's a good question. They should have been. I certainly haven't got a copy of the job description that I had then, but funnily enough, I can't remember.
On joining, prior to the separation of the business, what did you see your role as being in respect of prosecutions?
I don't think I had a role at that point. I think it was made clear to me by the then General Counsel that things that were in Royal Mail Group should stay in Royal Mail until separation. At that stage, we didn't even know whether separation would go ahead or not. So I think it was felt important to keep that structure in place.
Did you consider, for example, that you had a role in ensuring that the Post Office fully investigated the root cause of issues relating to the experience of sub-postmasters that led to them being prosecuted?
No, I don't think I did. I don't think... Interestingly, I'm not sure. I suppose it would have been Mike Young because the security team at that stage reported to him, but it was a strange arrangement because there was some security in Royal Mail Group, Tony Marsh, I think. So that's my recollection. And the legal team, the criminal legal team, I think, reported into the GC of Royal Mail.
So in respect of criminal investigations being carried out by the Post Office, as head of legal, you didn't see yourself as having any role in overseeing that?
I didn't know.
On separation from the Royal Mail, you became Legal and Compliance Director and became responsible for the matters that had previously been managed by the Royal Mail Group. You've said in your witness statement that in early 2012 you had discussions with Rob Wilson and Jarnell Singh. I think you met up with them, is that correct?
So my recollection is that I went to see them in Queen Victoria Street, which was where they were based. I think it was very early in 2012. And I think I certainly remember going there and having a conversation with Rob Wilson and Mr. Singh.
And it was just those two individuals?
As far as I recollect, yes.
Was there any formal handover process, or was that the extent of it?
Again, from memory, that was the extent of it. Then when we separated, Mr. Singh came across, if you like, with his portfolio of work. And we, as many separations go, we didn't get any choice as to which lawyers came over. People cheaply transferred, effectively. So Pole people who were working solely for Pole transferred over, and Mr. Singh transferred over in the same way.
And taking each of those individuals separately, so Rob Wilson and Jarnell Singh, can you assist us with your views as to their competence and their abilities?
I can't comment on Mr. Wilson. I'm not sure I had a view about competence per se, but I had a view about, if I might call it, attitude, and their view of sub-postmasters and their view generally. And I think some of the correspondence indicates a rather unhealthy view of sub-postmasters and what they felt their responsibilities to the business were.
Can you expand on that, please?
A little, yeah. So I'm trying to remember exactly sort of how I formed this conclusion. I think what I'd seen was it was encapsulated in this is public money, we have to protect it, that's our job. And there didn't seem to be a step in the process, well, I didn't see one, it probably was, a step in the process which said, hang on a minute, you know, should we be doing this? As a business, should we be doing this? Is it the right thing to do in this context? It seemed to be too much of a straight-through process.
And in that respect, are you talking about individual cases or the overall prosecution scheme?
Some of the, I think both probably. But you're going to ask me which cases now, and I can't remember.
No, I'm not. We don't need to deal with individual cases, but is your concern one of a step within the prosecution process that didn't consider the public interest sufficiently, for example?
I think that's right, and I think so. In early 2012, I recollect having a conversation with Paula Venables about the fact we prosecuted, and that the board needed to be involved to understand that. And, you know, I think I remember discussing it with her, but then because of the second site intervention, it got put on the back burner.
Who put it on the back burner?
Probably me, because I was waiting for the outcome of the investigation. I should have pushed it through regardless. You know, I should have just tried to go ahead.
Sticking with Rob Wilson and Jarnail Singh, prior to the second site report, did either of them have a conversation with you relating to bugs, errors or defects in the Horizon system?
I can't recollect having that conversation with either of them.
I mean, we know, for example, that Mr. Singh was involved in the Misra case. Did you have a conversation with him about his knowledge of bugs, errors or defects arising from the Misra case?
I can't recollect doing that.
Do you think it's likely or unlikely?
I would have thought it would be likely, but I can't remember.
Moving on to board meetings, we spoke yesterday about your exclusion from a particular board meeting. But you've also said in your witness statement that board meetings were, in general, by invitation only to you as General Counsel. Did you find that unusual at all?
Yes, previously where I'd worked as part of the sort of senior advisory team, if you will, to the business, you would be invited to the board meeting whether or not you had a particular matter to present. Just so that you could give advice to the board, and you were a bit of and often you do that by being company secretary, but actually company secretary is a job on its own, really, and so therefore when I wasn't company secretary, I didn't necessarily go to the board meeting.
And had the logic of not inviting the General Counsel to the board been explained to you at all?
So, not specifically, but I was aware that the chair at that time wanted to try and reduce the number of people at the board meetings. Again, my recollection is she was trying to ensure there was a better discussion, and whilst the board was developing, so she didn't have too many people in the room, because there's a lot of discussion about what the right number is to have on a board.
Did it suggest to you in any way an attitude or a culture relating to legal issues?
I suppose I felt, bearing in mind I'd really worked for two American companies for most of my working life, the American companies had a very different view of what the role of a general counsel was, and I felt coming to Post Office, it didn't share that understanding of that broader role, and therefore, and because I was excluded from the board, excluded, not invited, not a regular attendee, I wasn't able to develop that role at Post Office.
I'd just like to ask you some questions about certain things that were or weren't mentioned at board level. Yesterday I took you to board minutes from the 12th of January 2012, and it was minuted that you had told the board that the business had won every criminal prosecution in which it had used evidence based on Horizon integrity. Are you able to assist us where you got that information from?
So I think that would have come from either Rob Wilson or Jarnail Singh.
And are you aware that that information was not right?
I am now, yes.
And when did you become aware of that?
Probably reviewing the documents for this inquiry, I think. In that absolute sense,
yes.
You know, because it's a very absolute statement.
Yes. Did you think at the time this is a very strongly worded statement?
I should have been more suspicious, yes.
You say you should have been, that's probably in hindsight. At the time, did that cross your mind at all?
No, I don't think so. Partly because, you know, if people are making that very absolute statement and they're lawyers, and again, this is with hindsight, you tend to think, well, actually, they've been in the business a long time. They must know what they're talking about.
Two items that weren't necessarily discussed at board level. The first, Simon Clarke's advice on Gareth Jenkins, which also mentions bugs, errors and defects in Horizon. Can we just please bring up on screen poll 00039999? This is just a covering email. If we scroll down, please, we can see at the bottom Martin Smith sending you Simon Clarke's advice on Gareth Jenkins on the 17th of July 2013. We also have separately Simon Clarke's advice on document retention, the shredding issue, and that's an advice that I took you to yesterday. That can come down, thank you. Are those matters which, in your view, should or shouldn't be raised with a board?
They should be read. They should have been raised with the board, yes.
Were they?
I'm not sure they were raised in those terms. So I think the outcome of those were raised in the sense of we then had to review the prosecutions, look for new expert evidence. But I'm not sure, I can't fully remember, and again it would have been something I might have discussed rather than written down, about the fact that Gareth Williams was an expert we could no longer use, and to explain why that was so important to the board.
Does that fit in with a culture that we described yesterday of not writing things down and instead communicating them?
No, not for me, because I generally wasn't at the board meeting. So if I'd really wanted, if I absolutely knew, I think I discussed it with Paula. I can't remember now. There was a lot going on at the time, which, so
taking each one of those, both of those separately, when do you think you discussed them with Paula Venables?
I think pretty soon after I got the advice, certainly with regard to Gareth Jenkins. In fact, I think there's a note somewhere in one of the briefing papers about us having to, you know, do the criminal. As I say, it's the outcome of that as opposed to the process.
But would you have gone into some detail about the advice that was received in respect of reliance on Gareth Jenkins? Would you have, for example, told Ms Venables that there had been an expert whose evidence was unreliable and which was used in criminal prosecutions?
I can't remember, but it's likely that I would have done.
Document retention, the shredding advice, that's obviously a very serious allegation. Would you have discussed that matter with the CEO?
Again, I can't remember, but yes, I would have think it's likely I should have done, would have done.
Should have done or would have done?
Should have done.
And do you think you didn't?
I can't remember. I really can't remember.
Do you think that that is such a significant issue that should have been raised at board level?
Yes.
And can you assist us with why it wasn't?
I just don't think there was the opportunity.
Attention, please. Attention, please. This is the system. There is no need to take any action.
You've said in relation to the shredding advice that you didn't think that there was the opportunity to raise that at board level. Can you assist us with what you mean by that?
I'm trying to remember what the sequence was, and we've looked at there are a number of briefing papers in the pack, both old evidence and the new that's come through. I would need to go back through those to find out, to track it through. But as far as I can recollect, there wasn't a board meeting. There were board update calls. So I would have put it in the brief. If the briefing had come to me, I think I would have put it in the briefing note. But I don't think we've seen it in that.
I'm sorry, I'm not quite following this. You, I think, very fairly have accepted that the purport of the advice about Gareth Jenkins and the what we're calling the shredding advice should have gone to the board.
I am, yes.
Yeah. So the question of timing, which is what I regard as being the opportunity point, surely is secondary to putting in place a process which ensured that at some time it got to the board.
I agree.
Right. Now, you weren't attending the board, so you couldn't personally just turn up at a board meeting and raise it. So what should have happened to ensure that it got to the board at some point?
What would normally happen is that you would talk to the CEO or the chair or the company secretary, but really in Poll it would have been one of those two, and said, this needs to come to the board, or I need to bring a board paper. These are the things it needs to cover. It's urgent. It needs to be done, more quickly, and to schedule either a board call or an ad hoc board meeting. That's what would happen in other companies.
Right. So are you accepting, and I'm putting this neutrally for the moment, that you personally should have alerted either Paula Venables or Alice Perkins to the fact of those advices and suggested to them that it should be raised they should be raised at board level? So
I think what I did was to raise the outcome of those. So in other words, the review of the criminal cases. I think that was raised as part of the board paper and as part of the updates. I cannot remember whether the whole piece was raised as part of the board updates. So in terms of our expert witness being discredited, as opposed to the second site report, which disclosed the bugs that Gareth Jenkins raised, and the Helen Rose report needing to be disclosed to in respect of past criminal cases.
I appreciate that you have told me that you can't remember precisely, or even in general terms perhaps, what happened, but my question was about what should have happened, all right?
Yes.
Are you accepting, either with the benefit of hindsight or for that matter with foresight, that it was your responsibility as the senior lawyer to receive these advices, to put in place a process which ensured that the board became aware of both of them?
Yes, I do accept that. But what I would say is that it wouldn't be my general practice to send board members advice from counsel. It would be my general practice to send them a summary of that advice as it related to the board, if you will, or the business or the business.
No, I follow, and I'm not, in terms of my questioning, asking you, should you have sent the advices? But I am, I think, getting from you the answer. Ms. Crichton, should have put in place a process whereby the substance of those advices should have got to the board.
That's correct.
Yeah. Okay, thank you.
Moving on to a different topic, remote access. Can we please bring onto screen FUJ 000815884, please? This is a document from October 2010, and I'll make very clear you're not an attendee at this meeting. There's no evidence that you ever received this document. But did you work with Ian Trundle or Andrew Wynne?
Not as far as I can recollect, no.
This relates to the receipts and payments mismatch issue, and if we turn over please to page 3, there are proposed solutions to the problem, and we've seen, the inquiry's seen this a number of times. Solution 1, it says, alter the Horizon branch figure at the counter to show the discrepancy. Fujitsu would have to manually write an entry value to the local branch account. Impact, when the branch comes to complete next trading period, they would have a discrepancy which they would have to bring to account. Risk, this has significant data integrity concerns and could lead to questions of tampering with the branch system and could generate questions around how the discrepancy was caused. This solution could have moral implications of Post Office changing branch data without informing the branch. Now, prior to the allegation made by Mr. Rudkin during Second Sight's investigation, were you aware of the ability to alter the Horizon branch figure?
I think where I would have been aware, but it was probably as part of the Second Sight review, is about transaction corrections.
Mr. Rudkin, during that process, said that he had visited the Fujitsu headquarters and was shown how to access and amend the live Horizon system.
Yeah.
Do you recall that allegation?
I do.
Prior to that allegation, did you have any awareness of the possibility of doing something like that?
Not as far as I can recollect, no.
Can we please look at a transcript that has been recorded from a conference call with Second Sight? It's INQ 00002021, please. The inquiry's obtained transcripts of a conference call with yourself, Alwyn Lyons, and Ian Henderson of Second Sight. This one is dated the 22nd of May 2013. I'm sure you'll be familiar with the issue. It was recently reported on Channel 4 News, albeit not obtained from this inquiry. You've had a chance to look at this transcript, and I think your lawyers have fed back on various corrections to the transcript.
Yes, we've run the transcript against the recording.
Yes. Could we turn to page 57, please? And this is where the issue of remote access is addressed. And I think if you scroll down, we can see some wording is in green, some is in red. The green has been agreed between both yourself and also Alwyn Lyons as to who is speaking, for example. The red is not agreed, but I don't think it actually makes any difference for the purpose of the question that I'm going to be asking. I'll just read to you a brief section from this transcript. It starts from Ron Warmington, and he says, if James says something like, and where are you on this assertion about the Bracknell Covert Operations Team, as it was referred to by Rudkin, and remember, he's got a direct line to Shoesmiths, they're chummy apparently, so they will have told him about this for sure. So you know, if he challenges her on it, and you reply, say, well, that's a specific case, and then we go over the page, please. It's unclear. You say, come back to when we finish the investigation, and Ron Warmington says, yeah, as long as she doesn't come back and say, well, he mentioned this Bracknell issue, what is he talking about? Oh, we've known about that for, 2 months. And you say, no, she knows about the allegation, and Ron Warmington says, oh, okay. And you say, she knows, we're working on it. Ron Warmington then says, that's all right then, okay, good, good, good. And you say, so we mentioned it to her. He says, okay. You say, we've all been going, well, that is all very odd. And he says, but I think she needs to be prepared for the, the journalist type question, And you say, when do you last beat your wife type question. And he says, yes, and in relation to sort of Bracknell, can you assure me that there is not some, backdoor, some remote capability, at Bracknell or elsewhere, that had been used to the detriment of sub-postmasters? And you say, she won't. I mean, and Alwyn Lyon says, I don't think James will ask her. If he did, I think she could quite rightly say, my understanding is that that's one of the things in the spot reviews, and that's what we're looking at. So, we'll get to it when we've gone and looked at the evidence, James. I think, that's where I would push her in that. And he says, okay. I think Alwyn Lyon says, I don't think she's going to start talking about cases, to be honest. Did you speak to Paula Venables about the remote access issue prior to this recording, this meeting?
As far as I can recollect, yes, that's what I say.
Yes. And what can you recollect from that conversation?
I think it probably was part of, so I don't remember the actual conversation, but it would have been, it is likely that it was some update around the Rudkin allegation, the fact that we were investigating it, the fact that that went back to 2008, that I'd asked the Simon Baker, who was the project manager, to assist. We'd started looking for the emails. So I think Ian had just got a dump of the emails. And we're trying to understand what was going on in the building. So my process was to investigate, to try and prove or disprove that this was correct.
This meeting was on the 22nd of May of 2013. When approximately do you think you had a conversation with Paula Venables about that issue?
I think it would have been, so it would have been before that.
Long before that? Shortly before that?
Well, the Rudkin case came in, I think, according to the papers I've got, from around about February. So I think it would have been some, and I'm sorry I can't be more specific, but it would be between then and May. But I think it would be rather towards the beginning of that, because I think we'd have said one of the spot reviews we're working on is this, and this is what the allegation is, and this is how we're working on it.
And at that stage, did you or Ms. Venables or anybody else that you were working with have a view as to whether there was or wasn't substance in that allegation?
I didn't have a view. I was trying to find out what the facts were.
And how about others?
I don't know what others people thought. I mean, I think we were concerned. It felt like it was obviously a very concerning allegation, and we had to investigate it.
You were going to say it felt like a...
It was a strange allegation, and it was very specific, which is why I felt we really had to investigate it and find out what had happened. But it was very difficult because it was, I don't know, 5 years ago.
Paragraph 164 of your witness statement, you've pointed to an email exchange as confirmation that Fujitsu didn't have means of accessing the system, or at least confirmation that you had been told that they didn't have such means. Can we bring that email onto the screen, please? That's POL 0002965. It's an email from the 16th of June 2013, so the next month, from Steve Alcorn. Who was Steve Alcorn?
My recollection is he worked for Leslie in the IT team.
To Leslie Sewell, copied to you, and he forwards on an email. And if we could scroll down, please, to the email on page 2, the top of page 2. It's an email from somebody called James Brett, who is a senior test manager at Fujitsu. The email begins by identifying that in 2008 they were in test preparation mode for, I think that's Horizon Online, and in parallel supporting testing of the existing Horizon estate, in the basement at that time, there would have been 4 separate test environments, and he identifies the environments. And he says, along with these environments, preparation activities were underway in the basement to build a volume and release environment for Horizon Online, but these environments would not have been in a working state at the time of the statement. The post office had access to the functional test environment, and I've asked people in my team around the time, and no one can recall any external visits or Mr. Rudkin specifically. So the suggestion at the top there is that in terms of the basement, there is a testing environment that wouldn't have had access to live data. But if we scroll down in this email, he has another paragraph there, and it's an important paragraph. It says, for perspective, there is live access available at Bracknell, and there would have been in Horizon days too. I think that's legacy Horizon prior to Horizon Online. However, this access is available only to Fujitsu's SSC, System Support Center team, who provide expert support to help desk staff. They are based on the 6th floor, which is the most secure floor in Bracknell. Visitors are by appointment only and are not allowed to be unattended. The SSC team follow strict protocols relating to access and interrogation of live data, and their access is logged and auditable. There is no access to SSC systems from the basement. So do you accept that, looking at this and reading this now, an email that was copied to you, you were in June 2013 in receipt of an email that confirmed there was live access available, but it was on the 6th floor of the building?
I think in my witness statement I say that yes, I've obviously received that. My attention wasn't drawn to it, and I'm afraid I probably just looked at the first couple of emails from Steve Alcorn and Leslie.
Yeah, so if we scroll up, please, to the first page, there's no mention of that paragraph in the covering email that was sent to you. By the time you left the business, were you aware that Fujitsu could have live access of some sort?
I can't remember being aware, so I don't know whether I was or not. I don't think I was.
Do you recall, for example, discussing the matter with Leslie Sewell?
I might have done, I can't recollect that.
I'm going to move on to a different topic, and that is external legal advisors. Starting with Bond Dickinson and Cartwright King. Can we please have a look at Poll 00186-725? And it's just a very quick matter of clarification. This is during the period of the spot reviews, and we're in May 2013, and there's an email there from Roderick Williams to Simon Baker referring to Bond Dickinson settling a response to a spot review and signing off by Alwyn/Susan. What exactly was Bond Dickinson's role in signing off, or in formulating or settling the Post Office's response to the spot reviews?
My recollection is that we collected response to the spot reviews that Second Sight had done, and Simon would have pulled those together from a number of parties. And then, because we didn't have many people on the ground in terms of legal team, that we asked Andrew Parsons from Bond Dickinson to review these to make sure they make sense, hung together, and just as a review process.
Was it just a review, or would they input substantively?
I can't remember that.
Moving on to Cartwright King, what was your view as to the service that was provided by Cartwright King?
So I think there are 2 points there. One is we looked into the process, we reviewed them, but actually none of us were really qualified to review their processes because we weren't criminal law experts. So I should have got somebody you know, with hindsight, again, as I say in my witness statement, to review that process more carefully. I recollect that they told me that they were responsible for the prosecutorial compliance, if you will. But obviously I understand that one can't outsource that, just as in financial service you can't outsource your compliance responsibility. But I think that I should have done more around that more quickly after separation. So
you inherited Cartwright King as a firm that was already used by the business, is that correct?
Yes, that's correct. It came over on separation.
And upon separation, did you take any steps to satisfy yourself that they were competent to undertake the role that they were undertaking?
So we did some due diligence in the sense that my head of legal went up to Nottingham, I think, to meet with them. I think he went with Mr. Singh, so they would have explained how they operated. Then they came to see me, and we had a conversation about, again, how they operated, what their lines of communications were into the business, how they got their information, and how they managed that. I'm afraid what I didn't do is really do a drains up on their processes to see that they were compliant.
And if you had, what do you think you would have found? What are your concerns now?
Well, I suppose having listened to some of the evidence, particularly with regard to the Misra case, well, that would be Mr. Singh, sorry. Having listened and having read what I've read, my concern was that they weren't taking their obligations seriously, that it had just sort of rolled over from being Royal Mail legal and they were acting in the same way as Royal Mail legal had acted. But I don't, but I'm not a criminal law expert, but that's certainly how it seems to me.
Can we look at poll 00006541, please? And can we start at page 2? Thank you. If we could scroll down on page 2 to the bottom email. We have Hugh Flemington emailing a number of people, but emailing in particular Simon Clark and Martin Smith of Cartwright King, what is called a first rough draft from Second Sight of one half of the interim report. I can tell you, having looked at this as a standalone document, that it attaches what's called version 18A of the Second Sight report. Were you sent a number of different versions of the interim report? I know you mentioned 2 yesterday, but were there multiple drafts?
There must have been, because I think the final one was version 24 from memory.
The final draft or the final version?
I think that was the final version.
And did you input into those drafts?
Certainly one of them was the document that we had a discussion around on the 1st of July. I couldn't say which draft that was. Now.
Did you input substantively, though? Were these typo corrections? Were they crossings out? Were they adding words?
No, they were really discussions about whether the statements were backed by the evidence that they had found. So I wasn't seeking to wordsmith it necessarily, because it was obviously Second Sight's report, but I was seeking to verify that it was evidentially based.
And did you do that by comment boxes, track changes?
No, we had a conversation. I think they came in again on the 1st of July. We walked through, we had a discussion about it, and we tried to agree the way forward, and then, as far as I can recollect, Ian Henderson took it away and produced another draft, or another version.
Turning to the first page and the bottom email, please. Martin Smith has now received this draft report, or half of a draft, first half of the interim report, and he says as follows. He says, "Our advice overall with regard to disclosure has not changed. The disclosure of a partial report would not meet with our duties or help the current situation. I think the disclosure of a partial report would provide partial information and give rise to adverse publicity and speculation. It would be far better to advise once we have seen the entire report. Having said that, the second site report would not need to be disclosed in every case. That decision would be taken on a case-by-case basis. In many cases, it will not be disclosable. Did you have any concerns about that advice?
At the time, I don't think I did, no. I was relying on Cartwright King as criminal lawyers to advise me on disclosure.
If we scroll up, please, we have a response from Roderick Williams. He says, how could the interim report be used by those who had been prosecuted, whether found guilty or not, i.e. those who complain about being subjected to the stress, etc., of prosecution? Do you recall anyone raising any concerns about the advice that had been received in respect of disclosure of that draft report?
No, but it was the reason, I think, in order to verify the process that Cartwright King had suggested and were undertaking. That was why I had asked Bond Dickinson to instruct Mr. Altman to review the process and to review the disclosure process and to advise whether we should go further. So after the sifting process and the disclosure process, in order to ensure that we were meeting our obligations.
Thank you. Come down. We had Simon Clark advise of the need to conduct a review on the 8th of July 2013. Moving on from there, I'm going to take you to an email of the 16th of July. It's poll 00192214. Can we please look at the third page, the bottom of the third page? You say at the bottom of the third page, Andy, we received a letter from the CCRC yesterday, which I've asked Cartwright King to review. Their advice feels odd to me, as if given on a take-it-or-leave-it basis, and I'm not comfortable that's particularly useful in this context. Could we discuss? I'm happy to go to another firm that specialises in criminal law or a barrister. Somehow it feels as if there is a conflict here, which I'm not sure I understand. Can you recall this conversation?
I can recall the response coming in, and I can recall looking at it and thinking, and also more generally thinking, that I wanted to make sure that the process we were doing was correct. So that's why I really wanted to get somebody to take another look at it, because I didn't feel I was competent to say whether the sifting process and whether the disclosure process was credible in the context of what we were looking at.
Were you concerned about a potential conflict of interest at Cartwright King, and can you explain that to us?
So it was, you know, as we say, marking your own homework. And whilst I wanted to get the process started, and I think they started in July, I felt getting it started was the right thing to do so that things got moving quickly, particularly in relation to prosecutions that were ongoing or due to come to trial. I also felt that we needed to be sure that the process that they were undertaking was credible and the best that could be done in the circumstances.
And Brian Altman was instructed to provide his observations. Can we please turn to his interim review? That's poll 00006583, please. Was the purpose of this instruction for the reasons that you have just set out, that you were concerned about a conflict of interest, or was it something else?
I think it was that general, is this a credible response to the position we find ourselves in?
Thank you. So this is his interim review. Can we please turn to page 6 of that, which sets out some conclusions. He says as follows: I can conclude on the available information that the approach of Cartwright King and Council appears to be fundamentally sound, but the following issues need addressing by the Post Office and/or Cartwright King, the first being the geographical limit, the second being the temporal limit of the review. And on conflict of interest, he says as follows. He says, I can foresee circumstances where a conflict of interest might arise, where Horizon and/or, I think that's Gareth Jenkins, are the focus of a complaint. A hypothetical example may suffice. In a given case, it may be alleged that Dr. Jenkins did not properly fulfill his role as an expert witness because he failed to disclose something that Second Sight's interim report has now revealed. If Dr. Jenkins were to claim, when confronted by such an allegation, that he had in fact informed counsel and/or a representative of Cartwright King of the very thing he is now said to not to have disclosed, that would give rise to a clear conflict. And if there were a conflict of recollection about it, then that might lead to real difficulty in Cartwright King's further involvement in reviewing the case. But then he goes on, if we scroll down, paragraph 18, he says as follows, there is, I believe, benefit in Cartwright King and its internal counsel identifying and engaging in the review of impacted cases as they are familiar with their case files and intimate with the process. But it seems to me it would be wise for me to dip sample some of their work in due course, and I may have to devise criteria of my own for those cases I feel I should review personally. What was your view about this advice?
That I thought it was sensible.
And did it lead you then to continue with Cartwright King? Were you ever thinking of not continuing with the Cartwright King process?
Not at this time, no. And I think what it did do is sort of assure me that, at least as a first step, it was credible, but it was sort of caveated with these other points, so in relation to the geographical, the temporal, and the possible conflict.
If we could turn to poll 00298-123 and page 3. It appears that the advice was sent by Mr. Altman to Bond Dickinson. Can you assist us with what Bond Dickinson's role was in the review of Cartwright King's work?
I'm not sure they had one particularly. I think I was probably just using them as a convenient way of instructing counsel. I think I did ask, sort of from a common sense point of view, because again, they're not specialist criminal lawyers either, for their views.
Was there any tension between the various sets of lawyers and law firms, be it Cartwright King, Mr. Altman, or Bond Dickinson?
I didn't feel so at the time.
And looking back at it now?
I think there could have been a level of defensiveness from Cartwright King, which I probably didn't appreciate.
Can we please look at poll 00337-138? Moving now to September 2013. Actually, sorry, yes, we're in August, still in August. If we scroll down to the second page, please. There's reference there, just below that, to a response by Harry Bowyer of Cartwright King to Mr. Altman's advice. If we scroll down, sorry. And then in the email above, you sent Andrew Parsons an email saying, thought you might be interested to see what started that particular hare running. Can you recall this discussion at all?
I really can't. I can recall, because I think the Harry Bowyer's response was in response to Mr. Altman's questions in his interim report. and that was then sent to Brian Altman.
If we could scroll up, please,
Yeah.
to the very first email. We see you there say, we had a call with Cartwright King this morning, and we definitely need a conference with Brian when he gets back. We may need this in two parts, one with Cartwright King and one just with the post office. Need to work on tactics. Could you see when he's available? Can you assist us with what you meant there in terms of tactics?
So it sounds to me like I was aware that there was a conflict of interest and there was some possibly friction between Cartwright King and us. And possibly they were annoyed with... I'm speculating now, but it clearly looks like that's what I thought at the time.
When you say conflict of interest, in what respect?
It was my point about marking your own homework.
Can we now please turn to poll 00006485? We are now in September. 9th of September 2013. This is a conference with Mr. Altman. You are there in attendance. It's slightly confusing because there are two SCs in the minutes. So on occasion where there's a reference to SC, it's actually Simon Clark. We see there GM, Gavin Matthews from Bond Dickinson. He stated that the conference had been set up for three reasons. First of all, sorry, if we could scroll down, say, allow Brian Altman to get a fuller understanding of the review process, discuss the issues raised in his interim review and Mr. Bowyer's response, and to address the issue of the Post Office's continuing duty of disclosure. And it's the continuing duty of disclosure that I'd like to ask you about. Could we please turn to page 3? And halfway down, we have the advice from Mr. Altman. It says, Mr. Altman advised considerable caution in relation to mediation cases involving previously convicted individuals. Seema Misra has already indicated an intention to be within the scheme. The concern is that lawyers acting for those individuals may be using the scheme to obtain information which they would not normally be entitled to in order to pursue an appeal. Mr. Altman said that it was important that the Post Office and Cartwright King took control over all the information disclosed to these individuals by Second Sight so that the Post Office / Cartwright King were not blindsided by evidence that they were not aware of. The information being sent out to the individuals must be audited by Cartwright King. Do you recall anyone querying that advice at all?
No, I don't.
As General Counsel at that time, did that raise any concerns with you?
Yes, it did, because I wanted the mediation scheme to be able to go ahead. But there was this tension between the cases that had criminal prosecutions or I guess any cases taken against them and the fact of entry into the mediation scheme.
And did you at the time think that it was proper to withhold disclosure from somebody in a mediation scheme because it might give them an opportunity to pursue an appeal?
No, I didn't. I thought they should have the information.
Did you say so at that meeting?
I can't recall saying so.
Did anybody say so at that meeting?
It's not documented that they did.
And looking back at it now, what do you think went wrong there?
My view was that they would be able to be part of the mediation scheme and that we should give them the documentation.
Can we please look at poll 00116-136? This is a note of a meeting with Sir Anthony Hooper, with Paula Venables, Alistair Marnock and Martin Edwards. You weren't present at this meeting. It's a document that I took Sir Anthony to, and it's the second page, please, point E, that I'd like to ask you about. Sir Anthony advised as follows. He said that sorry was a good word. We should be prepared to apologise to sub-postmasters where appropriate during that mediation scheme. Were you aware of that advice?
No. Oh, hang on. So the 24th, I think Martin, I might have been copied onto the... I apologise. I have definitely seen the sorry was a good word attributed to...
It may be of assistance if I take you to one more document before
Okay.
you answer that. Could we please look at poll 000-66817, please? It's an email from Martin Smith to you on the 26th of September. And he says, thank you for your email. I've had a look at the note of the meeting with Sir Anthony Hooper, and then I'll read you two passages. If we could scroll down. He said, Brian expressed a concern that the slightest apology to a convicted person or the payment of compensation could indeed give rise to an appeal. He was concerned that Misra would use the mediation scheme to obtain some sort of concession to allow her to appeal. I note from paragraph 4E, Sir Anthony Hooper observed that sorry was a good word. If he intends to use it in relation to any convicted person allowed into the mediation scheme, the possibility of a successful appeal may well be increased. Do you have concerns about that advice at all?
So I don't remember getting this, and I was probably on my way out of the business. I remember the advice from Mr. Altman about, not because I think in one of the shorter form notes, he makes a point that I think somebody asked the question, should we apologise? And he said no. And it's a similar, and it's the opposing view here. I felt that if we were going to go through with the mediation scheme, then that had to be part of it. In other words, that we needed to disclose the information, and that if that was disclosed and that gave rise to the ability to appeal, then that's what should happen.
Did you express that to anybody?
I think so, but I really can't remember now.
In terms of the corporate approach to the mediation scheme, did that accord with the views that you've just set out, or were they different?
I think when it started, as far as I was aware, it did, because we shouldn't have. Well, I think it did. I think it did that because if you go back again to the chairman's note about the conversation she and I had, then some time before this, she was at that point anyway, which was being mid-2012. That was part of her rationale for saying that it needed to be looked at and opened up.
Having received this advice, did the approach change?
I really don't know. I was on holiday from the 27th of September, and I really didn't go back into the business.
Looking at it now, is it advice that you think was sensible or unhelpful?
So to me, it doesn't work together with the mediation scheme, but I think I was coming at that from a very different place.
Thank you. Very final topic, and I'll be very brief. I can come down, thank you, is the devolved administrations. You qualified in England. Did you have any knowledge of Scots law, for example?
No.
Did anyone in your team have such knowledge?
Not as far as I'm aware.
Do you recall looking into Scottish cases or Northern Irish cases as part of the reviews that we've been talking about?
I asked Cartwright King to manage that process as part of their review process, and I think they updated Mr. Altman with what they were doing in that respect. And I think they'd appointed local firms, again from memory, both in Scotland and in Northern Ireland, to take part in that process with them. And it's in one of the documents, it might be the Harry Bowyer advice.
Yes. And You spoke yesterday about a decision not to continue with prosecutions where Horizon played a significant part or some similar kind of test. Was that in any way communicated to, for example, the Scottish or the Northern Irish authorities?
No, not as far as I know, because it was with the investigation team. So I presumed it would be the investigation team who would need to make that, they would be the gatekeepers of that.
And are you aware of the investigations team having informed the devolved authorities that there was this concern about continuing prosecutions?
No, I'm not aware of that.
Thank you very much. Those are all the questions I ask. We have some very brief questions from Mr. Steen, Miss Page, and Miss Dobbin. They've assured me that they're only going to be 5 minutes each.
Before they ask their questions, there's just one thing I'd like to go back to. Could we have the note of the conference with Mr. Altman of the 9th of September, 2013?
That's poll 00006485.
And through you and Ms. Crichton and Mr. Blake, is there any indication in that consultation, I should say, note, that the advice relating to Mr. Gareth Jenkins was discussed?
I don't know the answer off the top of my head. I'm sure we can find an answer to that, though, sir.
All right. If you would, please. Then, and I'm sorry I'm having to do this from memory, but in the email chains which preceded that conference, my recollection is that I think it was a solicitor from Cartwright King asked that the advice by Mr. Clark about Gareth Jenkins be sent to Mr. Altman.
Yes, so that's poll 00337-138.
Thank you.
And it is the bottom email. Well, this may be a wrong reference from me, or we may be talking about the same document, but it's not necessarily the same advice. If we look at the bottom email, there's an email from Mr. Parsons that says, I'll forward Cartwright King's note on to Brian. But that I think, is Mr. Bowyer's note rather than...
Yeah, I think Mr. Bowyer wrote an email suggesting that Mr. Clark's advice be sent. And I wanted to check I was right about that before asking the question that I want to ask Ms. Crichton. I tell you what, let me ask you the direct question, Ms. Crichton. Can you remember whether or not the advice written by Mr. Clark about Mr. Gareth Jenkins was sent to Mr. Altman as part of his instructions for that consultation?
I think it was, and in his interim note of early September, I think he refers to Gareth Jenkins' expert evidence, the need for disclosure, which then tees up a discussion around the conflict of interest point.
All right.
So if I could bring onto screen poll 00006583.
Yeah.
And it's paragraph 1, subparagraph 2. And Mr. Altman's note, this advice is 2nd of August 2013.
Thank you. Thank you. I've traced down what I wanted to know. Thank you very much. Right, over to those who are asking their 5 minutes worth of questions.
I think we'll start with Ms. Dobbin.
Ms. Crichton, I ask questions on behalf of Gareth Jenkins. The inquiry has seen a note dated the 2nd of September 2013. I won't bring it up on screen, but it records it's notes of a conversation between Mr. Roderick Williams and Mr. Smith of Cartwright King. And the handwritten notes indicate that it was said at that point in time that it wasn't thought that Mr. Jenkins had been advised of his expert duties. And the question was asked, what were we doing to instruct GJ? Can I ask whether you were made aware in September 2013 that either Mr. Jenkins hadn't been instructed about expert duties or that there was a serious question as to that?
I don't think I was.
Would you have regarded that as significant information and information that you ought to have been provided with?
Yes, I think that's correct.
And why is that?
Because it would obviously be part of our responsibility as a prosecutor. And then going forward, in terms of Cartwright King, it would have been part of their responsibility as well to ensure that that was done.
So in other words, you would have understood that it would have gone to much broader questions about the competency of poll prosecutors and those who were conducting prosecutions on behalf of Post Office?
I'm not sure I would have done at that stage, no.
Do you think that you would have needed further advice in order to understand that?
It's hard to put myself back in that position now. Probably, yes.
And can we take it, this was the position in September 2013, can we take it that you were never apprised of that information?
That's my recollection.
And can we also take it that Mr. Altman wasn't provided with that information either when he came to provide advice to Post Office, as we've seen?
I'm afraid I can't help you there because I can't help you. I don't know the answer to that question.
Thank you.
Thank you, Ms. Dobbin.
Ms. Crichton, my name is Sam Steen. I represent a large number of sub-postmasters, mistresses and employees at branches. I've got two topics I want to ask you about. The first one relates to Second Sight, and then the second topic I want to ask you about is then you're leaving Post Office, okay? All right. Now, you've been asked a number of questions today by Sir Wynne, Chair of the Inquiry, about the clerk advices and what happened in relation to them in terms of discussions with the board. Can I then turn that around to discussions with Second Sight about the clerk advices? So the Jenkins advice, did you bring that to the attention of Ron Warmington at Second Sight or Ian Henderson at Second Sight?
So I can't remember, but on one of the transcripts, they're talking about how good Mr. Jenkins is as an expert witness. And I have a feeling, and it's only a feeling, that I did mention it to Second Sight, but whether it was in terms, I don't know.
Okay. Now, obviously, there's going to be evidence given from, I think, Mr. Warmington later in the inquiry, so we can talk to him about that and what his recollection. Can I just tease out a little bit more in relation to that? One of the matters that's important about the Jenkins clerk advice, do you agree, is that Mr. Gareth Jenkins is not just someone who was providing evidence under the label of expert for Fujitsu, but also someone who was a principal architect of the Horizon system. Do you agree? So it's two things about Mr. Jenkins that's important.
I hadn't, yes, if you put it like that, I think that's obviously correct.
Because Mr. Jenkins is someone that's been embedded in the system, the Horizon system, from word go, and also dealt with bugs, errors and defects within the system. Do you agree?
That's certainly the evidence that I have seen. I wouldn't have said it was I wouldn't have characterised it in that way probably in 2013.
But you agree with that now?
Yes, I think,
Yes.
again, with hindsight.
All right. Now, can I then turn to the instruction of Mr. Warmington at Second Sight? Now, if I've got this right, you worked at General Electric in increasingly senior positions for, what, 6, 7 years?
8 in the end, yeah.
8 years. And during that time at General Electric, you worked with Mr. Warmington, is that correct? He was a fraud specialist?
So Ron Warmington was part of the global fraud team, I think. And he also provided, if you like, service for us in EMEA, and he worked on 2 cases with me.
And you knew him, in fact, from that background to be a thorough and deep digger in relation to matters in which he is engaged. Is that fair?
That's correct. And in addition, one of my colleagues at GE Consumer Finance was Chief Compliance Officer Jane Wexton, and she'd worked with him at Citibank.
So it came to the position in relation to the Post Office that the Post Office had instructed, I think, 3 out of probably the 4 big audit-type firms in the past. Is that right? KPMG, that sort of firm.
I can't remember, but yeah, probably.
And there was a need to ensure that the a team that was brought in to do the Second Sight job that it did was going to be acceptable to MPs, Mr. Arbuthnot, now Lord Arbuthnot, is that right? And others?
Those were the instructions given to me by the chair at the time.
Okay. Now, Mr. Warmington, someone with the attributes that you've described, in other words, thorough and deep diver in terms of his expertise, did you expect Mr. Warmington to do an unexpectedly thorough job?
No, he did the job I expected him to do.
Which is to be thorough?
Yes.
Yeah. And so it went from your recommendation in relation to Mr. Warmington. At that point, had he actually set up the firm Second Sight Limited, SSL?
So if I can just take a step back, I actually rang Ron Warming to ask him for suggestions because I thought he'd retired.
Right.
And I thought, he might know somebody who could deliver on this brief because he's much more knowledgeable in that area of forensic investigation than I was. And he said, I can't remember whether he said he was going to, but he said he had this firm called Second Sight with Ian Henderson. Right.
And Ian Henderson, equally, is someone that turned out to be very good at the detail.
Yes, I think if you look at his CV, that's what you would expect.
Yeah. So, Miss Perkins and Miss Reynolds, they hadn't had this knowledge of Mr. Warmington as being this sort of, very thorough, get-to-the-detail type. But they nevertheless interviewed him, is that right?
That's correct. And although you have said, and other people have said, I recommended him, I don't think I did. I think I was neutral and said, this is their presentation. And because I also knew as Ron Warmington and Ian Henderson, and they made it clear to me they wouldn't take on the role if Post Office wasn't prepared to commit to giving them access to the information that they would need.
Do you recognise now, Ms. Crichton, that the instruction of Mr. Warmington and bringing with him Mr. Henderson was a turning point? In other words, that they did their job. They got as deep as they could do. We know what happened. Eventually their services were let go by Post Office, but they did what they could in the time that they had. Do you accept that? That was a turning point in these events.
Yes, I think that's right.
Without that stepping stone, we probably wouldn't have had the information available for the High Court litigation and so on. Mm-hmm. Do you agree with that?
Yes.
Now, one last thing in relation to your resignation. You deal with that in your statement at page 100. Did it come to the point where doors were being closed to you so that your access was being increasingly limited within your role as General Counsel, and that led to your resignation?
I think, as I said, and I think, the quotes from the meetings yesterday, I felt I could no longer perform my job. And it's partly because when you lose confidence of the chair, the board, the CEO, you can't stay as general counsel. So it's sort of more than doors closed. It's you just don't have a right of audience, if you will. You're discredited, and once you're discredited as a lawyer, an in-house lawyer, you can't operate.
And from your point of view, the document that was a note of a meeting with you at a coffee shop, it refers at one stage to you perhaps putting professional ethics above maybe the interests of the post office. Is that something that you recognise, that you're someone that tried, with the mistakes that you've accepted, to put your professional duties properly at the front?
Yes, I did. I did try to do that, yes.
Do you feel coerced? Is that too strong a word?
I just was put in a position where I couldn't do my job. You know, I just couldn't. I just couldn't continue to do my job because I couldn't deliver on it.
Because there's no other option, you resigned. Is that fair? When you resigned, did you sign an NDA, a non-disclosure agreement?
Yeah, a settlement agreement which included an NDA, yes.
And have you been released from that now?
I hope so.
Thank you, Ms. Crichton.
Can we fit in Ms. Page before a break? I'm conscious of the transcriber. How do you feel?
So I would very much like to, because we do have to move on to the next witness.
Mm-hmm.
Thank you. Flora Page. Can I take us to the January 2012 board, please? Poll 0002 1503 at page 6. Down to page 6, please. And if we scroll down a bit, we see that there's reference to Susan Crichton. If we hold on there, please. So, significant litigation report. Susan Crichton explained that the sub-postmasters were challenging the integrity of the Horizon system. However, the system had been audited by RMG internal audit, with the reports reviewed by Deloitte. The audit report was very positive. And then skipping over the claim about criminal prosecutions, you suggested that you clear the audit report with the external lawyers and, if possible, give the report privileged status and circulate it to the board. So thank you, that can come down. Ms. Crichton, can you please take it from me, given our time constraints, that internal audit report, reference poll 00029114, was circulated to you, and in fact it said this, amongst other things: it is difficult to detect and prevent inappropriate changes being made to master data. That was referring to Fujitsu and saying that there were problems with the controls around how you accessed master data. That had built on and responded to Ernst & Young reporting on the same issue in March of 2011. And this internal audit report, as at January 2012, said that none of the problems around controls that had been highlighted by Ernst & Young the previous March had been resolved. So March 2011, Ernst & Young say serious problems around controls and accessing master data at Fujitsu. Come January 2012, RMG internal audits say they're still not resolved, none of them. In the aftermath of your January 2012 board, you've, according to emails, made sure that Alice Perkins received that RMG internal audit report. And in the process, contrary to what your remarks to board suggested, it's discovered that Deloitte's involvement is not something separate. There is no separate report from Deloitte's. In fact, there is just a Deloitte secondee who's worked on the RMG report. All right, so no Deloitte's external report. Ernst & Young, nothing resolved. RMG internal audit, still some serious flags and question marks. That internal audit report is then put into the April board papers, just after your significant litigation report for April board, but you don't correct anything of what you said in January. Now, do you have any recollection of this, and as to why it would be that you didn't correct a board any of these issues that in fact were very live and very problematic?
No, I'm afraid I don't.
Well, then just lastly this, and see if this helps to jog your memory at all. In May 2012, there was a briefing prepared, and if we bring that up, please, it's poll 00033825. And I believe that you've had a look at this because this was part of your papers and you deal with it in your statement. This is a pack for James R. Buthnott and Oliver Letwin. And elsewhere in this pack, we can see that it was a meeting at which Paula Venables, Alice Perkins, who we know from the email I just referred to, had received the RMG internal audit report. And indeed, the whole board had received it by now in the April papers. And also Leslie Sewell were all involved with this. And on page 12, we see, if we go down to page 12, we see external scrutiny. Horizon and Post Office Systems Environment have always been subject to external scrutiny for both assurance and accreditation purposes. Ernst & Young carry out an annual financial systems audit. An independent auditor also carries out a yearly audit. We'll skip a bit down, please, and then just the last bit. In addition to these regular audits, final sentence on the page, ad hoc independent audits of the system are initiated by Royal Mail Group and supported by Post Office Limited. So this is 1 month after the internal audit report had been put into the board pack, in which it was clear that the Ernst & Young issues raised in the previous year had not been resolved, and there were still some serious concerns around Fujitsu's control of master data. Why were the MPs being told that all was hunky-dory and external scrutiny was fine?
So I think what this paragraph says is that there are a number of audit processes which are carried out in relation to the Horizon and other financial systems in the Post Office. The reference, presumably, so there's the PCI audit, there's the Vocalink, and there are a number of other independent audits. But the issue really is that those audits look at different things. So I'm not trying to excuse it, but I think it's like trying to compare apples and pears. So those audits wouldn't necessarily be general, wouldn't necessarily look at your point around master data. So I'm not saying that that's necessarily wrong. For instance, Ernst & Young carry out an annual financial systems audit, and that's what drives the issues flagged in the management letter. I think also with regard to the management letter, there was an element of progressing towards getting things done, as well as things that hadn't been done.
But wouldn't you accept that putting it in this format and this being a sort of a briefing which is trying to give the MPs a sense that everything's okay, the suggestion is that these external checks are telling the world, Post Office, RMG, and these MPs, you don't have anything to worry about?
I think it says what it is. You know, audits are done by people like PCI, Vocalink, WorldPay, HSB Payment Systems, and they give that accreditation. So, and also we'd had, I'm not sure we'd have had it by then, but the SAS 70 or it might be, it's not ISO. So there are various ways of looking at the financial systems, and I think what this does is list what is done. But I suppose what I would say is that you need to be quite in the detail to understand what it's really telling you.
What do you think James Arbuthnot and Oliver Letwin would have felt differently at that time if they'd been told that in fact Ernst & Young and the RMG internal audit were raising serious question marks over Fujitsu's controls of master data? Do you think they would have been as happy with the way things were going or not?
I can't speculate on that. I don't know.
Thank you. Those are my questions.
Thank you, Ms. Page. So that's it, is it, Mr. Blake?
It is, sir. Unless you have any questions.
No. Well, thank you very much, Ms. Crichton, for your detailed witness statement and for giving evidence to me for longer than one day. I'm grateful to you for participating in the inquiry in this way.
Thank you very much. So if we could take our 10-minute break now and return at 11:25, please.
Certainly.
Thank you very much.
Good morning, sir. Can you see and hear us?
Yes, I can.
Thank you. If I may... Oh, sorry, sir.
No, before you start, I was wondering whether, because we've proceeded as we have this morning, whether in order to achieve a reasonable break, rather than trying to fit 10 minutes in between now and 1 o'clock, we could carry on till, say, about 25 to 20 to 1, and then just take lunch then.
I'm content with that. I'll just look at the transcriber. Yeah. Yes, sir, we'll proceed on that basis. Thank you.
Right, thank you.
If I may call Mr. Aujard.
I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Please, can you state your full name?
Christopher Charles Aujard.
Thank you for giving your evidence to the inquiry today. You should have a bundle of documents and a witness statement in front of you. Could I ask you to turn that up, please? Do you have a witness statement dated 15th of March 2024?
I do.
And that witness statement runs to 398 paragraphs. Is that the one you have?
It does.
For the record, that is document reference WITN 000301000. Before moving to ask you to confirm the contents of that statement, I understand there are 4 changes you wish to make to it, 3 of which are typographical and 1 is more substantive. We'll go through the typographical ones first. If we could have the statement on the screen, please, page 150, paragraph 272. I'm sorry, actually, I've taken that out of order. Page 65, sorry, first. And if we could have paragraph 120, yes, that there, thank you. 2, 3, 4, 5. About 6 lines down in brackets, it says usually me. Our civil litigation lawyer, Rod Williams, Ms. Vandenbergerd, and Ms. Crow. I understand you wish to strike out our civil litigation lawyer, Rod Williams, and then add at the end of Ms. Crow, and more occasionally, Rod Williams, our civil litigation lawyer. Is that correct?
Correct.
Could we then turn, please, to page 166, paragraph 298?
Yes.
Just over halfway down, the word management appears at the start of the line in quotation marks. The start of that sentence is, normally I would understand management to include the board, and I understand you want to insert a not, so it reads, normally I would understand management not to include the board.
Correct.
And the final typographical one, sorry, again, I've gone out of order, is page 150. Paragraph 272. I think we can all see what it is already. In other words, as at 3rd June 2024, that should be 2014. Is that correct?
Correct.
I think that concludes the typographical changes. If we could now turn, please, to page 42. Paragraph 87. This sets out that, to the best of my recollection, I did not authorise any prosecutions during my time at Post Office Limited, and as it would have been an unusual course of action for me professionally, I believe it is something I would remember had I done so. I understand you want to make a clarification to that following receipt of further documents from the inquiry, which you did not have when you drafted this statement.
I do.
Could you make that clarification, please?
So the full sentence should now read, to the best of my recollection, I did not authorise any prosecutions during my time at POL that was based on evidence derived from the Horizon system, and any references in this statement to a moratorium on prosecutions is confined to Horizon-based prosecutions, unless stated otherwise. I am aware that towards the end of my time at POL, November 2014, I gave approval to Jarnel Singh to instruct Cartwright King to proceed in the case of Singh and Kerr, a case of theft that did not involve Horizon issues. This case was heard in the Rotherham Magistrates Court on 22 January 2015 and should not be confused with a similarly named case brought in the Midlands in 2009.
Thank you. So, with those changes in mind, could I ask you please to turn to page 217 of your statement?
Yes.
Is that your signature?
Yes, yes, indeed.
And bearing in mind the changes you just made, are the contents of your statement true to the best of your knowledge and belief?
Yes, indeed.
That stands as your evidence in the inquiry. It will be published on the website shortly. I'm going to ask you some questions about it now. Before I do, I understand you'd like to say a few words.
Yes. I want to say, so I'll start by saying how deeply sorry I am to the sub-postmasters, sub-postmistresses and post office employees for the anguish and suffering that you and your families have had to endure. I know that for many people here and for many of you, this has come far too late, but I hope that the evidence that I can give today will help get to the heart of what has happened. And in so doing, I hope that will stop something like this from ever happening again. Thank you.
Thank you, Mr. Aujard. I'll start briefly with your background. You were admitted as a barrister and solicitor of the Supreme Court of Victoria in Australia.
That's correct.
And you were admitted to the role of solicitors in 1992, the role of solicitors in England and Wales.
Correct.
And you practiced as a solicitor for around 8 years before transferring to become an in-house lawyer.
Correct.
And before joining the Post Office, your principal areas of practice were financial services law and regulation and mergers and acquisitions.
That's correct.
You joined the Post Office Limited as Interim General Counsel on 14th of October 2013.
Correct.
And you held a series of fixed-term contracts with the Post Office until you left in March 2015.
Correct.
I want to start with your role as General Counsel. You say it was Interim General Counsel, but while you were in that position, you effectively had the role of General Counsel at the Post Office Limited.
I had carriage of that role for the period I was there on the basis that I would be replaced by a permanent successor.
We don't need to turn it up. In your witness statement for the record, paragraph 32, you say that necessarily an interim general counsel's role differs from somewhat from that of a permanent general counsel, particularly in regard to executive matters, and you describe it somewhat of a caretaker role, I think is fair to put it.
That's correct.
What was your understanding of your responsibilities as general counsel?
As I say in my statement, the understanding was primarily to ensure that the board and the officers and employees of POL were informed of legal matters to the extent that they needed to be or it was necessary for them to fulfil their roles, and that I also at the same time was responsible for managing a department of lawyers who were likewise providing legal advice to POL.
If I could ask you just to raise your voice or maybe come close to the microphone.
I'm so sorry.
No need to apologise. In advising on legal matters and legal risk, would you accept that a general counsel should be proactive in identifying areas of legal risk?
Yes, indeed, yes.
Do you accept that the following areas fell within your area of oversight? Firstly, the security and investigations teams at Post Office Limited?
Not as a legal matter, but as an executive matter. The head of the security team reported to me, yes.
Why was it not a legal matter?
He was not a lawyer, and the activities he undertook were concerned mainly with the safekeeping of physical assets of the post office, which I wouldn't describe as a legal matter.
Were you responsible for the Post Office's review of past convictions of sub-postmasters for theft, fraud and false accounting?
So the answer to that question is that the review had been initiated prior to my joining the Post Office, and I received, I believe, from recollection, updates as to how that was progressing. It was subject to oversight by Brian Altman, KC, and I took steps to assure myself that the review was going appropriately.
In terms of Brian Altman, KC was a member of the independent bar, yes?
Correct.
Not a member of Post Office Limited?
Correct.
In terms of the executive team who had oversight within Post Office Limited, did that fall within your remit?
Yes, it would have done, yes.
In your statement, you distinguish between risks to Post Office Limited arising from allegations made about the Horizon IT system and the risk of any underlying issues with the robustness of the system. Would you accept that they are connected?
Yes, indeed. From my perspective, an allegation relating to the Horizon system could arise in circumstance where there was an underlying fault with that system.
And would you accept that you had to have an understanding of whether or not Horizon was robust in order to perform your role as General Counsel?
The answer to that question is somewhat, because the system itself is an IT finance accounting system, and I'm not qualified clearly to opine on accounting issues, finance issues or IT issues. However, as part of the process, I believe I needed to understand, in a general sense, the types of concerns, areas in which concerns might be raised, but not have an understanding at any level of detail as to the fundamental operation of that system.
But if there was, say, an issue identified by a technical specialist, an issue with the Horizon IT system, you would agree that it would be important for you to know about that?
As I think I say in my witness statement, in circumstances where that gave rise to an allegation, and that allegation was one which was had some degree of legal implication, not simply an allegation relating to the font or colour of a particular statement, but something which had a legal connection, in investigating or in considering the legal component of allegation, I would, I believe, have to turn to and seek advice from the IT and finance teams as to the issues that were being complained about.
So when, for example, you may have been dealing with claims by sub-postmasters for compensation on the basis that the Horizon IT system was not reliable, when you were dealing with those, it would be important to know if an IT expert within the business had identified an issue with the underlying system.
The claims handling process was dealt with as part of the mediation scheme whilst I was at the post office. As part of the process that scheme operated, those complaints were investigated to some extent. Those investigations, if they revealed issues relating to the system, then those issues would have been referred to technical specialists familiar with those, either in the IT department, the finance team, or in a number of cases, those that dealt with network matters. If a result of that there was an underlying issue, it would have been considered as part of the scheme mediation process.
Well, we'll come on to that and look in it more detail in due course, and we look at your role in the mediation scheme. You've referred to external advisors, namely Brian Altman Casey, already. And you say that you relied on a variety of sources of advice from external legal advisors. Of course, you, being general counsel, were put in a position to provide the company with legal advice yourself, correct?
Correct.
And so if you received legal advice from an external source, it would be your responsibility to read it, correct?
If it's a legal advice that relates to a matter that I've commissioned, yes, the department as a whole received legal advice on a daily basis from many different sources, and that advice I would not normally read. So, for example, advice in relation to the procurement of the IT system was being dealt with by others in the team. That would not be advice I would review or be involved with.
Yes, but if the advice came to you, you would be expected to read it.
That is correct, yes, that is correct.
And whilst you may defer to an external loyal specialism, would you accept that you should try to critically analyse it and come to your own view on the advice itself?
Yes, that's correct.
Can we bring up a document, please? POL 20138-077. So this is a presentation given on the 17th of January 2014 regarding the mediation scheme. Could we please turn to page 4? And in the top right, it says core membership. What is that describing?
I believe, but can't be sure, that that is describing the membership of the internal team that was responsible for providing support to the mediation process. However, I can see from that core membership list that that appears to be a point-in-time description of who was involved then. My recollection is that that subsequently changed after this document was prepared.
One of the attendees listed is Andy Parsons. That's Andrew Parsons of the name of the firm has changed, but now Womble Bond Dickinson, correct?
Correct.
And in your statement, we don't need to turn it up, but it's paragraph 37.1 for the record. You say Bond Dickinson was so embedded within Paul that in many ways they acted as an extension of the in-house legal team. Can I ask here, what was Andy Parsons' role in respect to this scheme at this point?
I don't think there was a formal or a written document describing his role. He was, from to the best of my recollection, involved in many, many important meetings relating to the operation of the scheme. And also, as said in my statement, he was a source of institutional knowledge about what had happened to the post office in order for the scheme to be established. So he was both a legal expert and provided legal support and advice, often written advice, institutional knowledge about matters that had occurred in the past, and attended many, many internal meetings.
So when you said almost Bond Dickinson were an extension of the in-house legal team, would that include Andy Parsons?
Indeed, principally Andy Parsons, I should say.
And did his role, in your experience, go beyond that of a arm's-length third-party legal advisor?
Yes, he did provide advice on Bond Dickinson, I think now Womble Bond Dickinson letterhead, and unlike a secondee who is part of the team and has formal reporting lines into a company, his formal reporting line was and remained into Womble Bond Dickinson, and he was subject, I believe, to supervision and appraisals, performance reviews by the appropriate partner at Womble Bond Dickinson, whose name I'm afraid I can't remember.
And the advice you received from Womble Bond Dickinson and Andy Parsons, was that limited to formal legal advice, or did it include strategic and commercial advice?
It included legal advice, particularly in relation to the establishment of the scheme and the liability of sub-postmasters. The liability that the Post Office should bear under the scheme. It included advice that was strategic about how to approach matters, and to some extent it also included advice based on his general knowledge of what had happened in the past.
I want to start looking at the past convictions and start with your knowledge of criminal law. You say in your statement that you weren't well versed in the criminal law of England and Wales.
That's correct.
You referred to John L. Singh. Did you understand him to be well versed in matters of criminal law?
I believe I did when I joined. I thought that he had the technical expertise necessary to advise on matters of criminal law, yes.
And what did you think of his competence as a lawyer? Were you satisfied or dissatisfied?
As I say in my statement, I believe I was satisfied at his core technical competence. My recollection is that he was not someone I would go to for higher order matters to do with complex criminal issues. My recollection is also that he was rather underoccupied for much of my time at Pol because there were no prosecutions taking place, bar the one that I've referenced.
When you say a higher order matter, what do you mean?
So matters to do with the review of past cases and review of matters coming out of the mediation scheme was something that I referred to Cartwright King for.
You've referred to Mr. Singh being underoccupied. You were aware of his history as a prosecutor with Royal Mail Group and Post Office Limited.
Correct, yes.
Did you ever discuss with Mr. Singh whether he was aware of bugs, errors or defects in the Horizon IT system?
I have no recollection of any specific discussion with Mr. Singh about that. However, it was a very small open plan office space. The matters that were being considered as part of the mediation scheme were well known within the legal team. So I can't recall whether at any particular time I had a specific conversation with him or he had a specific conversation with me about bugs, errors or defects in the scheme, in Horizon.
Given his past history involving Horizon cases, do you think you would have asked him directly about bugs, errors or defects in the Horizon IT system and whether he was aware of them?
I believe that as part of the general induction into the post office, I would have met every member of the team and talked to them about matters which were of relevance to them. And I cannot recall, I'm afraid, whether there was any specific discussion with him about bugs, errors or defects.
Can you recall anyone in the legal team telling you of their own personal knowledge of bugs, errors or defects in the Horizon IT system?
No, indeed the opposite. I believe that when I joined the post office, the message that I received, not just from the legal team, but from other parts of Pol, were that there were no bugs, errors or defects apart from the ones identified in the second site report.
When you say other parts of Post Office, what other parts?
So that would be principally from those involved in the network, fellow members of the executive committee.
Could you name names, please?
The names, I can't, I'm afraid, recall the names of everybody there. Kevin Gilliand would have been one. Angela van der Boggaard would have been another. And they're probably the two principal ones, I think. That
Going back to your knowledge of criminal law, we've said that you were aware that, I'm just going to say Post Office, even though there was a split. You were aware that Post Office had brought private prosecutions in the past?
I was aware, in a general sense, of the prosecutions being brought. Again, as I say in my witness statement, I was very surprised, very, very surprised, when I discovered it was done as part of a general power for any corporation or individual to bring prosecutions.
We'll come to that. Just taking it in stages, you were aware that the Post Office prosecuted sub-postmasters for theft, fraud offences or false accounting?
Correct, yes.
Presumably you were aware of the criminal standard of proof, namely that the jury had to be sure of guilt to convict.
Correct.
You understood that Post Office owed duties of disclosure when it prosecuted cases.
Correct.
You understood that the Post Office was required to disclose documents it possessed or had access to that might reasonably be considered capable of undermining the case for the prosecution or of assisting the case for the accused.
Correct.
And you were aware that the Post Office owed a duty of disclosure following conviction.
Correct.
You were aware that Post Office relied on data generated by Horizon to prove its case in those prosecutions.
Correct.
And as such, it was essential that the data generated by Horizon was reliable in those prosecutions.
Correct.
Did you know that in some cases Post Office Limited had relied on expert evidence to demonstrate the integrity of the Horizon IT system?
Yes, when I joined the Post Office, I was provided a briefing, I believe on my second day, by Cartwright King, outlining the matters you just discussed and the history of prosecutions and the issues that have been raised in relation to Gareth Jenkins.
So you're aware of Gareth Jenkins, and you're aware that the Post Office had served written statements from Gareth Jenkins in some prosecutions relevant to the integrity of the Horizon IT system?
I'm not sure that I was aware that there were written statements, but I was aware that he'd been used as an expert witness.
Let's look at POL, please. 20108-136. That's POL 20108-136. Page 2, please. Could go to paragraph 3, please. Oh, sorry. I'm so sorry. If we could start on the first page, just to... it's my fault. I apologise. Is this the briefing note you were referring to earlier, produced by Cartwright King?
Yes, indeed.
If we could now go to page 2, thank you, and to paragraph 3. It says, to this end, prosecutors have relied upon statements of both Post Office Limited investigators and where expert evidence is required, that of Fujitsu Services Limited. In each case, a formal statement and testimony if required, explaining Horizon Online and those functions of Horizon Online relevant to the particular prosecution is provided by the lead investigator. Where it is necessary to provide evidence and testimony dealing with the integrity of Horizon Online or to explain technical aspects of the system and data, we have relied upon, it says Dr. Gareth Jenkins, an expert witness provided by Fujitsu. So looking back now, do you think at the time you were aware that written statements had been produced by Gareth Jenkins?
It's quite possible I was aware of the written statements at the time, but I have no recollection now as to whether it was written or oral expert evidence or witness the evidence that he was providing.
You were aware, weren't you, that as an expert witness in a criminal trial owed a positive duty of disclosure?
Correct.
And that duty consisted of or included a duty to inform the prosecutor of any material that cast doubt on his or her opinion or arguably assists the defence?
Correct.
Thank you. What, if any, knowledge did you have of the criminal law of Scotland?
No knowledge of the criminal law of Scotland.
What about Northern Ireland?
No knowledge of Northern Ireland.
What was your understanding of Post Office's prosecutorial policy in Scotland?
My understanding was that the prosecutions in Scotland were brought by the Procurator Fiscal and that in Northern Ireland a similar arrangement was in place where the Post Office was not bringing its own private prosecutions.
And how did you satisfy yourself that Post Office Limited was acting in a compliant manner with the relevant laws of Scotland in relation to criminal law and past convictions?
I believe at the time I joined, I had a meeting with, or shortly after joining, meeting with both Cartwright King and Sir Brian Altman KC, and my recollection of those meetings is that they satisfied me that there were no ongoing matters that required positive attention by me, or indeed by Post Office, to deal with jurisdictions outside of the ones that were being dealt with. In other words, I would have had a question and answer session with them and expected and encouraged them, as the incoming new General Counsel with no knowledge of what had happened previously, to identify any outstanding matters, recommendations or actions that I should take, having newly arrived in that post.
So, in summary, is it fair to say, in respect of Scotland and Northern Ireland, your understanding of Post Office Limited's compliance with the laws of those jurisdictions was you were entirely reliant on Cartwright King and Brian Altman KC?
And indeed, I wouldn't say entirely reliant, and indeed on internal briefings I would have received from others at the Post Office when I joined, to identify issues that were currently live. There was no, to the best of my recollection, no such live issues were identified as and when I joined.
Please, could we bring up Paul 406357? This is an advice well known to the inquiry, that of Simon Clark's on the 15th of July 2013 concerning Gareth Jenkins. This advice was provided to you with the Cartwright King briefing, is that right?
I believe so, yes.
Did you read it when you received it?
I believe that I would have read, I believe this is an annex, one of 6 annexes to a briefing note. I'm sure that I would have reviewed the briefing note, looked into the annexes for relevant issues, and to the extent that they had been flagged, I would have followed those up at the time. I cannot now recall whether I read this in detail or simply by way of this is a piece of background information you should be aware of, and therefore read it in that light. I suspect, but don't know, it was more the latter than the former. Here is some background information that you should be aware of, but which does not contain live issues.
Well, let's go back to the briefing note, actually, if that's what you read first. It's POL 20108136, please. And if we could turn to page 10, please. I'm sorry, I've given the incorrect reference. Page 5, please. If we could go to paragraph 10, sorry, thank you. It says, Dr. Jenkins' failure to mention the horizontal line defects in his expert witness statements or to Post Office Limited and Post Office Limited prosecutors rendered his written statements inaccurate and misleading. That failure amounted to a breach of Dr. Jenkins' duty to inform the defence and the court and Post Office Limited of those matters. See paragraph 6 above. This was an important and far-reaching failure, the consequences of which are only now beginning to crystallise. Of primary importance was the fact that had Post Office Limited been possessed of this material during the currency of any particular prosecution, it would have undoubtedly been disclosable to the defence pursuant to Post Office Limited's duty of disclosure. It's quite a startling paragraph, isn't it?
Yes, it is.
And what were your views when you read it on the seriousness of this issue?
I believe my views would have been informed by the general briefing, which was that this was an historic issue, recently discovered, but nonetheless historic issue, and that was being dealt with as part of the overall process that had been put in place to review cases by Cartwright King under the supervision of Brian Ottman KC.
You said it was historic. The middle sentence says this was an important and far-reaching failure, the consequences of which are only now beginning to crystallise. Mm-hmm. Do you think that can sensibly be described as historic?
The issue, the failure, I believe, is historic, and that's, I believe, how it's described to me at the time, a recent historic failure, which will continue to have implications for the Post Office in the future.
Given the significance of this issue, do you think the actual advice on which it was based, the Simon Clarke advice, is a background document, or should you have read it in close detail?
This is the July 16th document.
15th of July.
15th of July document. I believe that at the time, when I received this briefing, that I was given assurances that these issues identified in this briefing note were now all being addressed.
Who gave you those assurances?
Well, my belief, which may of course be based on an incorrect understanding, would have been at the meeting I had when I first joined the Post Office with Cartwright King, and I'm afraid I don't know the date of that meeting. Perhaps another way of expressing that is to say, when I joined the Post Office with no knowledge of criminal law, there were no flags raised to me saying that there are ongoing matters that need to be addressed, other than the ones that are already being addressed as part of the review process being undertaken by Cartwright King and Brian Ottman.
So, let's just break that down. Is what you're saying that there were issues in the past related to Mr. Jenkins giving evidence of which you were made aware?
Correct.
And that's what you're describing as historic?
Yes, correct. Yes.
But the review remained ongoing?
Correct.
Did you think the fact that Mr. Jenkins was alleged to be in breach of his duty as an expert was something that ought to have been disclosed in itself?
At the time, I don't think I'd turned my mind to whether that needs to be disclosed.
Why not?
The reason I believe that to be the case is that I received oral briefings from Cartwright King, from others in the Post Office, discussions with Jarnell Singh, and in none of those discussions was it ever put to me that the fact that he was in breach of his duty was itself a disclosable matter, or if I had turned my mind to that issue, I believe that I would have thought that the review process that was being undertaken by Cartwright King, which was described to me as extensive, would be dealing with this type of disclosure matter.
So let's start on whether or not you did turn your mind to it. I think your evidence was you didn't. Is
correct.
Do you accept that this matter fell squarely within your responsibilities as General Counsel?
Yes, indeed, yes.
And the advice you received, you ought to have approached critically and come to your own view on?
I don't believe that I would have been able to come to a view on the extent of disclosure obligations beyond that which was presented to me by Cartwright King.
Would you accept it was a mistake not to have turned your mind to this issue?
With the benefit of hindsight and knowing how events have developed since then, except that it's something that I could have pressed Cartwright King harder on and asked for, obtain more detailed answers. At the time, it seemed to me that I was being given a full and frank information briefing about matters that I, as a General Counsel, incoming General Counsel, needed to be alerted to and actions I needed to take.
Why with hindsight? I mean, this was a matter about a review of past convictions, wasn't it?
Correct.
It was of the utmost importance.
Correct.
And this was a startling, I think you accepted a startling allegation that had been made.
Correct.
Why did it require hindsight for you to say it was something you needed to turn your mind to?
With hindsight, I think references the fact that from the line of questioning, I discerned that there was no such disclosure made. And if that's the case, then I'm very sorry that it's something that has turned out that way. At the time, however, I was firmly of the opinion that I had been told about all matters that I needed to take actions about. This was not something that was firmly, or even to my recollection, even indicated to me in a vague way that was an ongoing issue that needed addressing.
Can we bring back up POL 201083136, please? And back to page 5, please. Paragraph 8 describes the Helen Rose report, and it says at the end, refers to an issue we don't need to concern ourselves with. The second point is, that issue was resolved. The importance of the report, however, was this. It was rather suggestive of the proposition that Dr. Jenkins then knew of other Horizon issues related to events which occurred in January and February of 2013. The effect, if not the substance of the report, was to cast a further shadow over both Horizon Online and those who had asserted its reliability in court documents and in court. So one of the issues that's said to arise from the Helen Rose report is it further cast doubt on Gareth Jenkins. Mm-hmm. Do you accept that?
Yes, yes indeed.
Could we turn to paragraph 14, please? Describes the review process, and it says the purpose of the review process was defined as being to identify those cases where, had we been possessed of the Second Sight and Helen Rose reports during the currency of the prosecution, would we have then been required to disclose some or all of that material to the defence? Why did you think it was sufficient simply to disclose those two documents and not to go further and refer to the allegations made against Gareth Jenkins?
I don't believe that I did turn my mind to that at the time. This was given in the context of a briefing to me as of current matters, and to the extent that there were additional issues that needed to be raised, I would very much have expected that Cartwright King bring that out to me in a briefing in very clear terms.
We'll move on to Mr. Altman's advice, starting with POL 406581, please. So this is Brian Altman's advice, general review of the review Cartwright King were carried out on the 15th of October 2013. That's the date of the advice. Do you recall reading this?
Sorry, what was the date again?
15th of October 2013.
So this would have been on my second day at the post office. I do recall receiving the document on that day, yes.
If we go to page 5, please. We see there's an executive summary, and then over the page, at Roman numeral 10, Brian Altman says, I agree that Gareth Jenkins is tainted and his position as an expert witness is untenable. Thus, a new expert should be identified as soon as is practicable. So Mr. Altman had been asked to advise, effectively provide a second opinion on what Cartwright King had said, yes?
Yes, as I understand it, yes, that's correct. It was before my time, but yes.
And his advice was consistent or in agreement with Cartwright King?
Yes.
Could we turn, please, to page 45? And paragraph 141 onwards. We see Mr. Altman is talking about failures of an expert with their obligations. You would have read this section, presumably.
I believe so, yes.
Could we turn to over the page, please, to paragraph 144? Again, this says on the Helen Rose report, in isolation, this may not mean much, but coupled with the fact that it was Mr. Jenkins who furnished the information about the two defects to Second Sight, it lends itself to the reasonable interpretation that his true level of knowledge about the integrity of the system in general and two defects in particular was far greater than he was prepared to reduce to writing in his several witness statements during the material period of time. So you knew that piece of advice from Brian Altman?
Yes, and in general terms, I knew that Mr. Jenkins was tainted as a witness. That was made clear to me upon joining the post office.
Can we go over the page, please, to paragraph 149? This goes on to say that as yet no new expert has been identified, far less appointed, to replace Mr. Jenkins, who is and was uniquely placed to give evidence about Horizon, which is an unhappy state of affairs about which little can be done. The Jenkins problem, even when a new witness is found, may not be at an end, because he will doubtless still remain employed by Fujitsu Services Limited, yet not be asked to report on or be called by Post Office Limited as a witness to speak to Horizon's integrity. What did you understand of that advice at the time?
I need to say that he could not be relied upon or used in the future. I'm not sure what I understood by the reference to he will remain employed by Fujitsu. and I'm not sure what was meant by the reference, yet not be asked to report on or called by poll as a witness. However, I should stress that's from reading the document now. I have no clear recollection of what I thought at the time when I read those words.
Can you see that there may have been a concern that a new witness or a new expert may be reliant on Gareth Jenkins to provide their own evidence?
Yes, indeed, I can see that, yes.
And can you see how that could cause difficulties for a prosecution going forward?
For future prosecution cases, is
Yes.
that correct? Yes. Yes, I can see that for future prosecutions that relating on that were based on evidence derived from the Horizon system, that would be an issue.
And potentially derived from Gareth Jenkins?
And potentially derived from Gareth Jenkins, yes.
Do you think that would have been your understanding of this paragraph at the time?
I'm afraid I have no clear recollection of that paragraph.
Thank you. Could we please bring up poll 30275150? And if we could go to page 2. This is a paper for the Post Office Audit Risk and Compliance Committee titled Prosecutions Policy. We can see, just to orientate yourself, it's page 6 of the document. At the bottom, please. Thank you. This was something, a report you prepared on the 9th of November 2013.
It would have been prepared by a number of people, but my name would have been put to it.
And you would have to satisfy yourself that it was accurate?
Correct.
Did you say correct, sorry?
Correct, yes, sorry.
So was this one of the first reports you would have drafted for a board subcommittee?
I believe so. This is 8th November. I've been in post for about 3 weeks.
Could we go, please, to page 2? Paragraph 2.1 says, in the last October CEO report to the board, an update was given on Project Sparrow, in which it was noted that a paper will be submitted to the November audit, ARC, reviewing our overall policy for investigating and prosecuting future cases. For convenience, a copy of the relevant section of that report is set out at Appendix 1.
Mm-hmm.
And this is the update you were providing. Can we go, please, to Appendix 1, which is at page 7. So it says Project Sparrow, and the third bullet point down refers to Cartwright King and the review of past prosecutions. And it says, our external firm of criminal solicitors, Cartwright King CK, has now completed a review of 301 cases subject to past prosecution to identify whether we have a duty to disclose the findings of the second site report and associated issues. What were the associated issues?
I'm afraid I have no clear recollection of what that phrase referred to.
Would you think it referred to Gareth Jenkins and the allegations that he was in breach of his expert duties?
It may well have done. I believe, from my understanding, at the time when I joined the post office, that Cartwright King were dealing with disclosure of all relevant matters to those that had previously been convicted.
If associated issues is referring to a matter such as Gareth Jenkins and the allegation he breached his expert duties, do Do you think the phrase associated issues is doing a lot of heavy lifting there?
No, I don't think so. I think that is a reflection of my general understanding of matters at that time. They were dealing with all matters relating to the disclosures in criminal cases.
But as a report to the, as a report from the CEO, would you expect a matter such as an allegation that an expert post office had been relying on was in breach of their duties, matters such as that, would you expect that to be described as associated issues or said expressly?
I would have thought that the paragraph has been written in such a way to reflect my then understanding that Cartwright King were dealing with all manner of matters relating to past disclosures. Now, that understanding may well have been incorrect, but I don't think that the wording there in any way indicates to the contrary.
Well, let me put it another way. When you came to draft this report in November 2013, did you know whether the board or a subcommittee of the board had been told of the allegation that Gareth Jenkins was in breach of his expert duties?
I'm not sure that I was aware at that time. No, I don't think I was aware of what the board had and had not been told.
Do you think you would have found that out when you were preparing a report for a board subcommittee?
I think that somebody, I would have expected to be brought to my attention if it was the case and if it was relevant to this paper.
So you would have expected what to be brought to the...
I would have expected someone to say that the board is or is not aware of something and this is material and they should know if they didn't know already.
Was it not incumbent on you to find out what the board is or isn't aware of before you update them?
My understanding of being 3 weeks into the job was I was heavily reliant on others to tell me what had gone on previously. I don't believe that issue was, to the best of my recollection, ever drawn to my attention in that stark manner.
So you can't assist at this time with whether the board knew of this, say, the 15th July
I just don't know.
Can we turn back, please, to page 2? And if we go down to paragraph 2.3, sorry, I should start at 2.2. It says, since that update, Brian Altman Casey has prepared 2 separate reports, one commenting on Post Office Limited's strategy and process for reviewing past and current criminal prosecutions in light of Second Sight's interim report. And it says the backward-looking report. That was the advice from Brian Altman we just went to, wasn't it? At 2.3, you say the headline conclusion of the backward-looking report is that the review of the cases that have been prosecuted over the last few years is fundamentally sound, and that no systemic or fundamental flaws in the review process were detected. In addition, a number of relatively small procedural recommendations were made regarding matters such as documentation, retention, etc. Do you think that's a full and fair account of the Brian Altman advice dated 15th of October 2013?
I'm not sure that I'm, without looking in fully at the context in which this was prepared, I'm not sure that I was able to comment on that.
Well, let me put something particular to you then. Do you think it was why didn't you refer to the allegation against Mr. Jenkins when summarising this advice?
As I said before, my understanding upon joining the post office was that all matters that had predated my joining were currently being dealt with as part of a review process undertaken by Cartwright King with the oversight of Brian Altman.
But that's what was happening on the review. That's a different matter to what the board knew.
And I'm afraid I had no knowledge at that stage. Well, I don't know whether I did or didn't. I have no recollection of the board the board's state of mind as to what it had been told and what it hadn't been told upon joining the post office, nor indeed I would have thought at that stage, which is about 3 weeks into the job.
Do you think you should have referred to Brian Altman's views on Gareth Jenkins or the Simon Clarke advice in this report?
I believe but can't be sure that my recollection there is that, let's put this another way, my working understanding at the time was that these matters had been all dealt with prior to my joining the post office, and that there had been a number of issues raised, that they'd gone through appropriate governance, appropriate people informed, and that steps taken to deal with them.
But the review was ongoing.
Correct, the steps were taken to deal with them, correct.
So was your position in respect to the review, it had been set up and it was just to take its course?
That was my understanding when I joined.
You weren't to look at that review critically and decide whether or not it was satisfactory?
My understanding from those in the post office was that it had been critically assessed and that it was adequate and appropriate for the purpose it was trying to perform.
And that's notwithstanding the fact that you received, well, I think you said the first day of your job or second day, the Brian Altman advice commenting on the adequacy of the review.
Yes, and I believe the overarching takeaway from that report is that it is adequate.
Let's just before we break, page 3, please. Paragraph 2.7 and 2.8. I don't need to read it out, but this refers to the considerations about recovery when determining whether or not to prosecute. Mm-hmm. Were you aware of, within the business of discussions about whether or not recovery of assets was a relevant factor to take into account in whether or not to continue Post Office's prosecutorial role?
I don't believe at that stage I was aware of discussions within the business about the use of Proceeds of Crime Act to expedite recovery of assets. But I was concerned to make it clear to the, I think this is a committee paper, make it clear to the committee that that was not something that should be taken into account.
Could we turn the page, please? If you go to options considered at the bottom, 4.3, please. Thank you. There's 4 options set out for consideration there, the last being ceasing all prosecutorial activity. And if we go over the page to page 5, paragraph 5.1, that's the proposal you recommended.
Correct, option D, which was to cease prosecutorial activity, but coupled with a business improvement programme.
And why did you make that recommendation?
So this is partly informed by both a personal view and a professional view. As regards to professional view, I did not believe that prosecuting was the appropriate way for commercial organisations to deal with their agents, their employees for that matter. My background, the context of that comment is I come from a financial services background where these types of matters usually dealt with in a civil court or dealt with by other means, certainly for lesser issues, maybe dealt with by means of an HR sort of process. That's the professional view. And a personal view, I felt that criminal prosecutions cause great distress and anxiety and didn't have a place in a business such as the post office.
To what extent did the difficulties faced by the position of Gareth Jenkins as an expert influence your recommendation to cease prosecutorial activities?
Not at all. Not at all. I don't believe they influenced my position at all. I think I would have written the same words had I not known about Gareth Jenkins.
Before we break, you said earlier, and in your witness statement, you saw your role as one of caretaker in so far as executive decisions were carried out. In one of your first papers, I think, to a subcommittee, was to advocate for the Post Office ending a centuries-old role in prosecutions. Is it fair to say you didn't shy away from making suggestions to change executive policy?
In certain areas, I think that's correct. In general terms, no. In general terms, it was to have carriage of the direction of travel or pursue the direction of travel that the Post Office course was set upon. On this particular issue, however, I felt very strongly, and that's why I put the words I did in that paper.
Thank you, sir. That's probably a good time to take the lunch break in, according to your indication.
Certainly. So we'll start again at 20 to 2?
Yes, sir. Thank you.